Hello, good afternoon. Today, my lesson will be about international treaties. I would like to give you a definition of this concept, of this legal notion, international treaty, and then we will discuss about the formation, the legal formation of this legal source and its legal validity if we have time. Maybe I will have also time to talk about legal effects, and then that's all. I want you to know general lines, general principles which are regulating this very important source of law in international legal order. The first question is, what is a treaty? The treaty is defined by very important Vienna Convention of 1969 by this formula. The treaty is an international agreement concluded between states in written form and governed by international law, whatever its particular designation. I repeat, the Article 2 of Vienna Convention of 1969. It's a very simple definition. The treaty is an international agreement concluded between states in written form and governed by international law, whatever its particular designation. And you can see from this simple definition, the treaty is first of all, written legal source of law. We have to not confuse the treaty with other sources of law, for example, with customs, with general principles of law, with judicial decisions, which can form jurisprudence, and also with public law doctrine. If you look at the statute of the International Court of Justice, you will find in this statute of Court of Justice, which is the statute is annexed to the Charter of United Nations. You can find it easily. In Article 38, this statute enumerates different sources of international law and international conventions, which are international treaties, I mean written legal sources, is the first quoted by, expressed by this statute of the Court of International Justice. So there is a distinction to make between written legal sources of law as international treaties, which are also named conventions or agreements or charter or understanding. The designation is not important. The designation, the name given to it by states is not important. What is important is the fact that this is, I am just quoting the doctrine. What is important that the treaty is the expression of concordant wills emanating from subjects of law endowed with the required capacity with a view to producing legal effects governed by international law. So the designation is not important. The important is the object, is the nature of this legal source. And I will repeat this definition of Jean-Marie Dupuy in French, which I'm translating to English. A treaty is the expression of concordant wills emanating from subjects of law endowed with the required capacity with a view to producing legal effects governed by international law. And we find in that definition that a treaty can be signed by states, which are subject of law in international law, but also by international organizations, which are also subjects of law in international legal order. So we can have conventions or agreements between states, convention or agreements between a state and another subject of law, which is the international organization, or a convention between two international organizations. We can give the example of the European Union, which is a member of the World Trade Organization. European Union is an international organization. World Trade Organization is an international organization. They conclude an agreement to make possible the membership of European Union in the World Trade Organization. As you know, European Union is not, for instance, a member of the Convention of European Human Rights, European Convention of Human Rights, but the negotiations are current now in order to make possible the accession of the European Union to the convention, to the European Convention on Human Rights, even though European Union is not a member of the Council of Europe. I want you to make very carefully distinctions between European Union and Council of Europe, which are not same international organizations. Treaties may also be a bilateral treaty between only two states, an agreement signed by two states only. It can be also a multilateral treaty, multilateral convention, which means that the treaty is signed and approved by by multiple states or organizations. For example, the Charter of United Nations is a multilateral convention agreement. Maybe last remark before to study the formation and the legal validity of treaties. The last remark will be about the absence of a clear hierarchical organization, clear hierarchical establishment between construction, between states, between legal sources of international law. Unlike national legal order, the international legal order has no clear principle of hierarchy. The international legal order has no clear normative hierarchy between written legal sources, which are treaties, and unwritten legal sources, which are customs, international customs, general principles of law, and judicial decisions. It is true judicial decisions and public law doctrine is considered like secondary, but there is no clear hierarchy settled between those different legal sources. We know in international legal order the principle of equivalence of legal sources. According to the principle of equivalence of legal sources, there is no fundamental hierarchy, unlike in domestic legal orders. In domestic legal orders, we have constitution at the top of the hierarchy, and then we have bills of the state, which have lower legal value than constitutional norms. We don't have this construction, primary construction, in international law. But we have some rules in international law, and one of those rules, we find it, for example, in the Article 103 of the Charter of the United Nations. And according to this Article 103 of the Charter of the United Nations, the UN Charter will prevail if there is a conflict between this charter and another international treaty. A second rule, which we find in Vienna Convention of 1969, is the jus cogens. Jus cogens is defined as a mandatory international rule against which it is not possible to undertake an agreement, and a convention, a treaty. So make it a little bit more clear. The Vienna Convention, in its Article 53, expressed that no convention is valid if it is contrary to a jus cogens rule, which is a mandatory international principle. For example, the principle of prohibition of genocide, it is a jus cogens rule, according to the International Court of Justice jurisprudence, case law. I'm thinking, for example, to the case Senegal against Belgium, the case of Hissène Habré of 2012. So there is basically no hierarchy in international legal order, but there are some particular rules which are creating somehow a limited hierarchical relationship between international norms. But basically, an international treaty is not superior or inferior to another legal source. Members, the states of international legal order are sovereign, and the principle of equality of state sovereignty in international law forbidden the hierarchy between legal sources of international law. After those preliminary explanation, I would like to speak about the formation and the legal validity of international treaties in international legal order. As we saw in the definition given in Article 2 of Vienna Convention, also in the definition of Professor Dupuy, the consent, the state will, is the most important ingredient, most important element of the formation of international treaty. A treaty is a conventional act. It is a little bit like a contract, but it is not a contract of internal law, of course. It is not a contract of civil or public law. It's a contract which has the nature of a public law legal source, because an international treaty is a legal source of public authority. So a treaty, an international treaty, is simply a legal expression of will of public authority. It can be states or it can be international organization. This expression must obey to a valid procedure. Even if international law is not formal, essentially formalistic, even if the international law is a consensual law, so form not matters, there are a minimum bunch of legal rules which must be respected. The expression of this will can be realized by different procedures. It can be a simple letter. An international treaty can be a simple letter. It can also be a common declaration between chief of states, an understanding, a memorandum. Form is not very important. For example, a mutual declaration of ceasefire can be considered as an international agreement. You can also think to the Declaration of Yalta in 1945 between victorious states of World War II. You can think to in 1975 to Final Act of Helsinki, which has created the Conference on Security and Cooperation in Europe. It became Organization of Security and Cooperation in Europe in 1990. You can think to gentlemen's agreements which are not formal treaties, but which are international undertakings, international agreements. So there is no specific international rule to let us limit the form of international treaties. But if we have a question about it, if we don't know how to proceed to qualify if an act, if a paper is an international treaty or not, we have to look some criteria and we have to qualify legally this paper as agreement or not, according to those criteria. They are not limited, but I will talk about 5 criteria. The first criteria is terms of the agreement. The second criteria is the nature of the paper. The third criteria is the object of the understanding. And the fourth criteria is the nature. No, it is the context. I'm sorry, there are only 4 criteria. Context. I will try to explain those 4 criteria. First criteria, the terms of the understanding between states or between international organizations. If in this understanding, in this written paper, if there is a date of entry in force, if there are obligations formulated, if there are rights formulated clearly, we can think that there is an international agreement, although the nomination, the designation of the act is not clearly said international treaty. Second criteria, the object. There are some kinds of things that we cannot decide without an international treaty. For example, a territorial cession, a territorial territorial giving up, a territorial separation between states. If there are understandings, if there are exchange of letters, or even if there are mutual declarations, we can consider that those tools, those instruments are international agreements, because the subject is very important. If the question is the territorial borders of the state sovereignty, this question is so important, only an international agreement can have it as an object. The third criteria is the nature. Of course, written papers are mostly qualified as international agreements. But as I told you, even a declaration, an oral declaration, can constitute an international treaty if this declaration is about a very important matter of international law. For example, a ceasefire, declaration on a ceasefire can be considered, even though it is only oral and not written, can be considered as an international treaty. The last criteria is the context of the treaty. We can qualify an understanding between states or international organizations as an international treaty if those states or those international organizations are acting as they were engaged in an international agreement. For example, if one of parties is proposing to register the undertaking, the agreement, to the United Nations Treaties registration. So if there are some behaviors showing that a state is considering this act as a treaty, we can tell that there is an international treaty established. It was the example in 2014 before the International Court of Justice in Peru against Chile case, where states are proposed to register the undertakings between themselves. So we can define a paper, a text, a textual, a written, or even a declaration as an international treaty. The international law is not formalistic, it's a consensual legal order. States are sovereign and their behavior can constitute freely the expression of their will. But there are several legal rules and two principles essentially. I would like to present you those two principles which are necessary to have a valid international treaty. Those are legitimacy and lawfulness. There are two rules to respect in order to have a valid international treaty, and those rules are legitimacy, the first rule, and the second rule is lawfulness. Let's make a stop a little bit, 10 minutes, and then I will begin again. Thank you for your attention.